Balancing the Scales, a look at entertainment law, presented by Brian Michaelz of Michaelz Management. Gordon Firemark and Tamera Bennett are responsible for a monthly entertainment law podcast online and also available at iTunes, focusing on entertainment law. Mr. Firemark is a Los Angeles attorney who represents artists, writers, producers, and others in the heart of the entertainment industry of Los Angeles and Hollywood, California. Mrs. Bennett is a superpower. Wife, mother, lawyer, mediator, blogger, podcaster, and legal writer with a practice that focuses on copyright protection and more in the entertainment industry. Mrs. Bennett has her practice in the Dallas-Fort Worth area, deep in the heart of Texas. As Firemark and Bennett focus on different issues pertaining to the legal liabilities of the entertainment industry, we will take a look at their podcast and top stories. Regarding the issue of trademark, we find Marilyn Monroe, who even after being deceased for many years is ranked 6th on the Forbes top earning dead celebrities. Her estate is currently bringing in over $17 million annually. However, one company that licensed Marilyn memorabilia, Avila, has filed a lawsuit that states that many trademarks are fraudulent. They have looked at getting the trademarks canceled in lieu of this case and the allegation of deceptive business practices. They are claiming that it is the monopolization of Marilyn Monroe's name, likeness, and image. This is a case that is going to have to be proven in a court of law, which will be rather difficult, but will be up to ABG, which is the company now handling the rights of Marilyn Monroe. Our next issue is one that is rather common in the entertainment industry, which is the copyright. An Egyptian composer, Balig Hamdi, brought a suit against Jay-Z and producer Timbaland regarding the use of his uncle's song, Kasera Kasera, which he claims was used in the hook of Big Pimpin'. However, international rights versus American laws are different. The composer went as far as to state he gave up the economic rights to the song, but did not give up the moral rights. It was finally found in the court of law that the songwriter did not have standing. However, this has been a lengthy litigation and has really detailed the dealings of international copyright law, as the case has been in litigation for over 8 years. The family in Egypt plans to appeal the decision. Jay-Z and Timbaland, after winning the court decisions, may continue to use Big Pimpin' in whatever way they may choose, including in records, films, and in concerts. When it comes to history, Anne Frank is a name that is a vital part of every history book. Now Miss Frank's own book is a topic of debate, as copyright expiration is an issue as of January 1st, 2016. There's a huge copyright claim, and as it stands, large copyright paradox 70 years after her death. The overall question is, will this upcoming date actually be the expiration of the actual copyright of The Diary of Anne Frank? The statute would also contest that the copyright is also country-based, but they are also stating that it should be based on the date of her father's death, which was in 1980, which would extend the date to 2050. The thing that is also complicating the case is that there are 3 different versions of the book. The Swiss-based foundation that is the universal heir to the Frank family says the copyrights for the various versions of her work won't expire for decades. The case remains open, and it is safe to say it will just be a matter of time. Fair use is a very touchy subject, almost as touchy as the First Amendment. When it comes to celebrities and publicity, this is when it all comes together and becomes the ultimate prickly pear. The Electronic Frontier Foundation is trying to narrow the protection, and they have filed a brief and want it to be that celebrities are listed under the First Amendment as well. This would set the record that the right of publicity be included under the First Amendment, meaning that they can talk about celebrities, actors, athletes, etc. The right of publicity is an offshoot of state privacy law that gives a person the right to limit the public use of their name, likeness, or identity for commercial purposes. It could certainly be contested that this could be less protection for the celebrities and more protection for those who want to use their name, likeness, and/or image as free speech under the First Amendment. Legal liability issues surround the entertainment industry daily, and anytime we look at building a business within the entertainment industry, we have to look at the liabilities that surround us. This has been Balancing the Scales, a look at entertainment law presented by Brian Michaelz of Michaelz Management. Your message, your music, your management. Contact us today at 888-363-6874.